Second reading on item number 5, please.
An ordinance amending Chapter 12 of the Raytown Code of Ordinances to conform to the language expressed in the 2007 Video Services Providers Act.
Our Finance Director, Jeremy Wilmoth, anything to add, sir?
Not at this time. I'd be happy to answer any questions you may have.
Any questions of Mr. Wilmoth? Discussion or Ms. White has the motion to approve.
Second.
Seconded by Mr. Kramer. Discussion before we vote on item number 5. Mr. Van Buskirk?
No.
No questions. Okay. No discussion? Once, twice? Call the vote, please.
Alderman White?
Yes.
Alderman Kramer?
Yes.
Alderman Ertz?
Yes.
Alderman Hamilton?
Yes.
Alderman Pardue?
Yes.
Alderman Van Buskirk?
Yes.
Alderman Azier?
Yes.
Alderman Lightfoot?
Yes.
Alderman Mock?
Yes.
Second reading on item number 6, please.
An ordinance adopting the Missouri Municipal Records Manual for retention of record schedules for the City of Raytown, Missouri for city documents and repealing Ordinance 856-74.
Ms. Henry, anything to add as a city clerk?
Nothing at this time.
Ms. White has the motion to approve, seconded by Mr. Pardue. Discussion on item number 6. No discussion. Call the vote, please.
Alderman White?
Yes.
Alderman Pardue?
Yes.
Alderman Ertz?
Yes.
Alderman Hamilton?
Yes.
Alderman Van Buskirk?
Yes.
Alderman Azier?
Yes.
Alderman Mock?
Yes.
Alderman Kramer?
Yes.
Alderman Lightfoot?
Yes.
Second reading on item number 7, please.
An ordinance amending Chapter 2, Article 1, Section 2-16.1 and 2-16.2 of the Raytown, Missouri Municipal Code, Open Meetings and Records Policy, aligning said policy to correspond with Chapter 610 of the Missouri Revised Statutes and rescinding Ordinance 3169-87.
As this is the second reading, any questions or discussion?
So moved.
Mr. Azier has the motion to approve, seconded by Ms. White. Discussion on item number 7. Call the vote, please.
Alderman Azier?
Yes.
Alderman White?
Yes.
Alderman Mock?
Yes.
Alderman Pardue?
Yes.
Alderman Lightfoot?
Yes.
Alderman Hamilton?
Yes.
Alderman Van Buskirk?
Yes.
Alderman Kramer?
Yes.
Alderman Ertz?
Yes.
First reading on item number 8, please.
An ordinance authorizing the mayor to enter into an interlocal agreement with the cities of Grandview and Sugar Creek for administration of and implementation of a Neighborhood Stabilization Program 3 grant award by the Missouri Department of Economic Development under the Community Development Block Grant Program and the Housing and Economic Recovery Act of 2008, designating the city of Raytown as the lead party for coordination and administration of such grant funds.
Mr. Mock, sir.
Yeah, Mr. Mayor, I wish to recuse myself.
Okay. Questions of Ms. Lynn as our Community Development Director for still a few more weeks.
Good evening, Mayor and Board of Aldermen. I just wanted to hit some of the highlights for the interlocal agreement that's before you here tonight as a first reading. As you know, we've been talking about the Neighborhood Stabilization Program for several months now. This is the final piece that goes with that as the interlocal agreement. The city of, as you'll remember, the city of Raytown is the lead party, and we are partnering with the cities of Grandview and Sugar Creek. Just wanted to call your attention to a couple of the items that are included in the interlocal agreement. It lays out the duties of the lead party for the city of Raytown, and then for each of the additional parties. The part I want to call your attention to is at the bottom of your RBA, and then continuing on to page 2. There were several things that the cities during the Neighborhood Stabilization Program have learned from this process, and we have been able to benefit from that and included those items in the interlocal agreement. The first kind of clarification that we've included in the interlocal agreement is the maximum grant amount that was awarded from the Missouri Department of Economic Development in the amount of $1,250,000. That's kind of a housekeeping item. The second two items are in a similar fashion, that it talks about the deadlines for expenditure of those funds, with 50% of the funds that must be expended by March 11th of 2013. Following on page 2 of your RBA, 100% of those funds must be expended by March 11 of 2014. Then the next couple of items are things that we've learned during discussions with other cities about the Neighborhood Stabilization Program and wanted to make sure they were included in the interlocal agreement so all the cities were on the same page and knew that we were kind of partnering all together. The first one talks about how we would divide the actual grant dollars that were awarded from the state of Missouri. When we were approached by Mid-American Regional Council and the city of Sugar Creek and the city of Grandview, we felt it was really important to as equally as possible distribute those funds. This is really meant to be a partnership and a cooperation in making neighborhoods across the metropolitan area stable. So we've included language in the interlocal agreement that says we'll do the best that we can to distribute those funds equally. The next bullet talks about the area median income requirements. As we've discussed, the grant funding has a requirement that 25% of the people who take ownership of the home must be at the 50% area median income level, which is the lower income level. What we wanted to make sure happened was that that requirement was spread over all 3 cities so that no one city was responsible for taking on the commitment to having all of that lowest area income. So we've included language in the interlocal agreement so that the distribution includes one of those persons in each community and also language for equally distributing them to the best of our ability. The next item is included or referenced as Exhibit E in your interlocal agreement, which talks about the affordability requirements. Whenever money is used for things like down payment assistance or other items that are included in the Neighborhood Stabilization Program, both the federal government and the state of Missouri have requirements for monitoring to make sure that that property remains with the property owner who received the funding assistance. The state sets those minimum requirements. So if you look in Exhibit E, it talks about the number of years that have to be monitored for the same ownership based on the amount of money. What we included in the interlocal agreement was reference to that state chart as Exhibit E as the minimum, and then each city could increase those monitoring requirements if they wanted to, but that would be done at their own cost. And there was some interest expressed from the city of Grandview that they wanted to have a minimum of 7 years requirement that they remain in the home, even though the state minimum is only 5. So what we indicated was the grant would reimburse for 5 years. If the city of Grandview wanted to go above the state minimum, they would have to pick up the expense of that and not have it come through the grant. And then the last one that talks about is a discussion about the excess program dollars. As you can imagine, as we kind of go through the process for the Neighborhood Stabilization Program, there is an opportunity where, and we would anticipate that the program would actually generate income on its own. When you purchase a house at a very low amount, are able to rehab it at a fairly low rate, and then would be able to sell it at a particular rate, there might be an opportunity for there to be income generated. At the end of the grant on March 11, 2014, if there is funding, excess program income that is left, not original grant money, but actually program income that's generated from the purchase and sale of homes and property, that money can remain with the individual cities. The cities will then, if there is money that's available, then the cities would submit a plan to the state of Missouri on how they would like to expend those dollars. And what we've included in the interlocal is the ability for those cities to try and divide those equally in the same fashion that we did for the original grant money, so that everyone has an opportunity to partake in those excess funding dollars. I would be glad to answer any questions. I know it's kind of has a lot of detail in it, but we wanted to be, in an effort to be transparent and upfront about this particular grant, we tried to include those items in the interlocal agreement. So just one other item, it is going to the governing bodies for both Grandview and Sugar Creek kind of simultaneously, that you all are considering it as well.
Okay, again, this is the first reading. Does anyone have any questions or comments for Ms. Lynn? Mr. Azier.
You may not be able to answer this, but why did the authorities who created this program not just allow each of the cities to be on their own rather than have one city be a lead party? Why that particular formality?
We chose to partner together with the other cities to make our application stronger. When you have a very small pool of money, your application is much stronger if you cooperate with other cities. And I think that's why we got the large amount of dollars that we did from the Missouri Department of Economic Development. If we had applied on our own, which I think we could have, our amount of dollars would have been significantly less, would be my guess.
Thank you.
Mr. Lightfoot.
Yes, 25% of the recipients need to be at 50% of the median income. Do we know what the median income is there?
We do, and I can include that in your information for the RBA next time. What we did was try to research what kind of professions are at that level to kind of give you an idea. And there's a lot of professions that are included in that, like similar to a city maintenance worker actually wouldn't be included in that 50% area median income. Paraprofessional in the school, some of those similar types of positions, but I'd be glad to provide that in the RBA for next time.
Okay, and then the only other question I had, and I brought this up the last time we talked about this, it's mandatory for most of the products on these houses to be the Energy Star. So there's a lot of rebates, government rebates, like for furnace, windows, insulation, all kinds of things. Will the homeowner be eligible to use that rebate money themselves toward the down payment of the house?
Sure. We have been discussing this with Michael Snodgrass, who was here previously from Builders Development Corporation, and I know they've been researching it. The difficulty is Builders Development Corporation is not eligible for those. Like, I think he talked about this when he was here. Right. He's trying to work with trying to figure out a way for that savings to be passed on to the ultimate property owner, and how to go about making sure that that is in line with the IRS regulations. So they're working on that.
Okay, that's a great program, and it would really help a lot of these people, I think.
Totally agree.
Thank you.
Other questions on the first reading? No further questions? We'll wait for that to come up for the second reading, and thank you. Next, we've got a discussion item, item number 9, inoperable vehicles. And Beth, I'm going to say this, hopefully you'll be at the next meeting as well, and I'll further elaborate on this, but you've done a fantastic job for us, and I'll further elaborate on that at the next meeting. We will miss you.
Thank you. The yellow memo that's included in your board packet tonight stems from some concerns that I had heard from several aldermen expressed about the presence of inoperable and unlicensed vehicles on commercial property, especially with regard to the corridor of Highway 350. Since the addition of or filling of the neighborhood services supervisor position, staff was kind of in a position and correctly staffed to initiate a sweep of Highway 350 for the violations of the current nuisance ordinance with regard to unlicensed inoperable vehicles. I will say in response to that sweep, we sent several letters to existing business owners along in that corridor for those types of violations, and heard from many of them. That's when we started to further investigate the existing code language, did a little bit of historical research on when it changed there in 2003, and tried to get a better understanding about why it changed, and then wanted to come to before the board tonight to have some discussion about really what's the board's goals, and does the code match that, and is there a way, looking for direction later on in the memo, if there needs to be code changes. The current ordinance was adopted by the Board of Aldermen in 2003. You have some language there about what the previous ordinance was that talked a little bit about declaring all partially dismantled, non-operating, wrecked, derelict, unlicensed, junked, discarded vehicles a nuisance, with some exceptions. It was not considered a nuisance if it was in an enclosed building or on the premises of a business enterprise operating in a lawful place and manner where necessary for that business, or an appropriate storage place. In addition, it did not allow the tearing down or kind of work car repair unless it was shown to be on a specifically authorized, permitted, or licensed business. Then, from the research I had done, pulling the previous city attorney files and the previous community development director files, it looked like the ordinance had changed in 2003 when the Board of Aldermen amended the nuisance to its current fashion. In doing so, the whole nuisance code now is set up to address 3 types of nuisances. The first is nuisance in general, the second is nuisance on a residential property, and the third is nuisance on property other than residential. That's meant to include commercial, industrial, those kinds of things. In your memo, first it talks about the residential purposes, where it's considered a nuisance if there's a dismantled, inoperable, or junked vehicle, unless it's stored within a building and can't be a harborage for like mice and snakes, or if it's being dismantled by its owner, then it can be there for 7 days. Also on residential property, they're not allowed to have a vehicle that is unlicensed for any period of time. The second area that it talks about on page 2 is for property other than residential. And this is really where we began to get concerns from the business owners, particularly along Highway 350. It talks that you can allow or cause to remain a vehicle that's dismantled, inoperable, or junk if it's stored within an enclosed building, or if you're validly licensed, you can have it for 30 days. However, you cannot allow any unlicensed vehicle at all. And really the challenges that staff ran into that, there's several. One, anytime where there's a time commitment that's in the code, it makes it very challenging for the code enforcement officers to enforce that for several reasons. One, it's very labor intensive to make sure that you go by on day 1. Then, technically, if you go by on day 5 and it's still there, then you would have an opportunity for the property owner to say, well, I removed it on day 2, 3, and 4. You just happen to go by on 5 and it's still there. Kind of take that all the way through 1 through 30. And then the other difficulty there is the way that our current enforcement process happens. For example, if we would send a letter to a business owner on January 1st that says, you have a junked vehicle on your property, if it's there after 30 days, then you need to remove it because the code only allows it for 30 days. If on April 1st they bring in a different junked vehicle, we would consider that a violation under the same ordinance, which they've already received notification of, and they would automatically get a summons. There's no warning letter for the second violation of the same type within the same calendar year. So you can imagine how perhaps the existing car repair businesses along Highway 350 had some concerns with meshing the goals of their business and in particular the nuisance code with inoperable or unlicensed vehicles. In addition, really the biggest difference that we found is the current ordinance has no ability for unlicensed vehicles for a legitimate car repair business. In having the conversations with many of those businesses, those unlicensed vehicles are a part of the business that they do. The cars come from an auction or another site or a dealership. They work on them, they return them, and at no point do they have a license while they're on the property of that car repair business. The other thing that staff noted was oftentimes, the way the current code is written, unlicensed cars are not allowed at all, even though oftentimes they look like any other car except that they don't have a license on it, while junked and inoperable cars are allowed for 30 days. So maybe there was a incongruence in the code at that point. We did a little bit of research on some of the surrounding municipalities and what they've done. You've got kind of a summary of that in your memo, just to kind of spur the discussion on what the Board of Aldermen thinks their goals are and what would best fit what we think for Raytown. The last page talks a little bit about the direction that we were really looking for from the governing body tonight. In discussing with the city attorney, we didn't want to go down a path of making really any changes to the code or suggesting those if the Board of Aldermen didn't feel like there needed to be changes or if you wanted to go in a different direction. So staff's provided some recommendation, but obviously we'll take whatever direction the board does and put that in code amendment format if that's how you would proceed. So some of the questions that we were looking for direction on or for discussion would be, should the current code provisions with regard to inoperable or unlicensed vehicle on residential property change? Excuse me. Staff's recommendation at this point is no. The current ordinance provides clear direction, and really this is something that we have not had problems with as far as the enforcement process goes. There are some people that don't like to abide by this particular code, but I think it's good for neighborhood preservation purposes. The second one talks about should the current code regarding unlicensed vehicles on property for commercial or industrial be amended. Staff's recommendation is yes, based on the feedback we got from the business community, that they really need the ability to keep unlicensed vehicles in order for their, especially for with regard to car repair businesses. So maybe there's an opportunity to allow businesses that are property licensed to, have those on their property, but that's really at the discretion of the board and how you want to proceed. The last one is a discussion about the current code for regarding inoperable or junked vehicles on those same commercial or industrial properties. Should that be changed, staff's recommendation is yes, for the removal or reevaluation of the time limit in particular, because of its difficulty for enforcement, and then also should they be stored in an enclosed building or a fully enclosed area if that's outside. So obviously we're here to hear discussion and get direction from the board on how they'd like to proceed.
Thank you. Mr. Ertz, first up.
I really appreciate all the work you did on this. I know some of it may be caused by me also. I'd just like to say I do agree that the residential law should stay the same. Personally, I don't have any problem with that, and it is good to keep our neighborhood's values in place. I agree that there is a need to have unlicensed vehicles at a repair business, before they would get taken to an auto selling business, if the business is properly licensed to have those. And I believe that they're not selling the cars there, is what you're saying, but it's more of a transfer point between the auction house and the car dealer lot, and I believe some type of a license for that would be good. And I also agree about the junked vehicles. And that is what probably gets me the most, is you can drive down 350 highway and see cars without even a body or wheels on them, and basically frames laying on the ground. And it's we're trying to redevelop 350 highway corridor and make it as beautiful as possible. I would hope that the businesses know that the value of their businesses also go by how that looks and what's around them. The other thing I would like to add maybe to the unlicensed vehicle part would be make sure that they were properly placed on the property. In other words, not on other people's property, not on the right-of-way, not on the grass. And I know that should go without saying, but let's say it anyway. Other than that, I think this would be great, and I'd be supportive of your suggestions. Thank you.
Mr. Kramer.
Thank you for bringing this up. I'm one of the people that call for anybody that wants to know. I work in the automotive business, and I understand. I work in the service end of things, and I understand that there are times you're going to have an inoperable vehicle, and that's what a repair facility is for. But you got to use common sense when it comes to that. And as Alderman Ertz said, there's one particular location that I drive by every day that's got a frame and a carcass of a van, and it's been sitting there for quite some time, and it's not pleasing to the people that drive through there. I know we've had a couple automotive businesses that have come before us and looked at doing business in Raytown, and one of the things that we require of them is to clean up their property and keep it in upstanding condition. And at the dealership I work at, we work on unlicensed vehicles that are going to go out on our car lot. We work on unlicensed vehicles for other car lots, but we try to keep it neat, clean, and tidy. And that's basically what I want to see. I want, I want to see us go that direction. As far as the neighborhoods go, I just want to keep things the way they are. But as Alderman Ertz said, we don't need them in the right-of-way. We don't need them in the grass. That's what scheduling is all about in the automotive business. And sometimes you can't plan for that customer that has their vehicle towed in. And but you gotta use common sense about how you do your business and how you keep it clean.
Mr. Pardue.
Yeah, since we're on this side of the board discussion, I'll go ahead and just agree with what's been said. I think the junk cars on 350 is the priority, and that's what we need to go after. But I think everything else is good.
Mr. Hamilton.
Just for clarity purposes, in number 3 on the last page, you're recommending, or staff's recommending, that you remove time limits for property owners other than residential purposes. What do you suggest how that should read then?
Our suggestion would be to require inoperable or junked vehicles be behind a fully enclosed area or within a building
From day one?
from day one.
Okay, well, that's what I thought, but I just wanted to clarify that.
Limit altogether, and I sense there may be existing business objection to that provision in policy, and I think that's why we're looking to you as aldermen. We think if we come with that provision, probably going to be some pushback, some of your existing businesses along 350 who have had a tradition of inoperable vehicles out in view.
Well, I would support from day one.
Mr. Mock.
Yeah, getting back to the fully enclosed areas, okay, enclosed buildings and fully enclosed privacy fences.
Yes.
Okay, all right, let's get to the chain link fences then. Right now I can't tell you how many that there's a few that are behind chain link fence today that has junk cars. And that are on grass today. So those have to be removed completely from the site.
Yes,
after this goes in. Now, if we get back to the chain link fences itself, so then they would have to go to a privacy fence.
Yes, sir. I would not consider a chain link a privacy fence or a fully enclosed area.
Okay, and that's what another question is, can we stipulate like a vinyl fence instead of wood? You know, wood throughout the years would deteriorate pretty quick compared to vinyl or anything like that.
The Highway 350 design standards have standards for fencing, so I can prepare that information to be included when we would bring the amendment forward to the code so that the board can be fully aware of what those standards would be.
Okay, one other question. There's one there at 67th and Blue Ridge. There's a wrought iron fence, vinyl fence across the back side that adjoins Rice Tremoni.
That one's a little bit unique because it has a conditional use permit and it has additional requirements through the conditional use permit process. I can pull that information for you and provide it, but I don't know the requirements off the top of my head.
Okay, thanks, Beth.
Mr. Van Buskirk.
Those that have conditional use permits now, will that change if we pass an ordinance to, will that affect those particular businesses?
So in a particular example that Alderman Mock's talking about, I personally have not seen inoperable vehicles. I've seen unlicensed vehicles there, and they would, if you would go with a licensed car repair business would be allowed to have unlicensed vehicles there, then that would be allowed unless their CUP is more restrictive. And that one, we can do a little bit of research on existing CUPs and what their requirements are and try and provide that to the board.
As you are well aware, Ms. Lynn, I've contacted you many times in regards to this issue. We've discussed it a number of times because there are multiple sites in our city where we have this problem, and especially on 350 highway, it certainly is a concern. I would be, my other concern is that we don't want to put some undue burden on businesses that are going to drive people out of business, but we do have to take action regarding this problem and do something to beef up the current ordinances so we can enforce it better. And I appreciate the fact that you've been working on that, and we're making an effort to do that.
I think that's part of the feedback we were looking from you is I think anything that increased costs in this environment, there's going to be pushback to you that you are making the operation of the business more difficult. But we felt strongly about the standard on the inoperable or junked vehicles that the enclosure requirement is a reasonable economic thing if you're going to have that condition. But we wanted to have your support in this feedback before we come forward with it, because I could see the staff being divided or the recommendation being divided to you individually from various operators who unfortunately have had a long tradition of 350 highway operation at less than that standard, Alderman Van Buskirk and Ertz. So I do anticipate that argument coming from those business operators. I'll defer to Mr. Benson or Ms. Lynn, though, if they've got more about the CUP issue. I hadn't thought about on that. I didn't think we would have a CUP that would permit inoperable and junk vehicles, perhaps unlicensed. We'll look at that issue for you more.
Thank you. I hope, as I said, I hope we can do something to beef this up and to put some more teeth in the ordinance. I think we just need to be cautious that we don't put undue burdens or an undue burden on our existing businesses, and just be I think, well, just aware of that and be thinking about that as we go into this. Thank you.
Mr. Azier.
I know it's been quite a while since we actually dealt with codes and unlicensed vehicles. I think it's been over 8 years. Since that time, I know that our codes or requirements to operate a business have gone up substantially. When new businesses open today, they've had to meet requirements that we didn't ask for 8, 10, 12, 14 years ago. And I think that what we're asking for here is to bring the older businesses that have been operating under the standards of Raytown 15 years ago, to bring them up to par with what we are expecting from the new businesses that are opening up every year in Raytown.
Second round, Mr. Kramer.
Well, and you kind of stole my thunder there, Mr. Azier. I had forgotten to point that out, but also in the automotive business, we create service tickets on the cars that we're working on. Now, when you got a disassembled car, that's one thing, but when you got an active car that you've ordered parts on or something like that, there's a service ticket that's generated with that vehicle and proof that it did come from a dealership or from an auction house or something like that. So in regards to the place on 67th and Blue Ridge, they do have unlicensed vehicles out there, but they've also got a license to sell. We allowed them to sell vehicles there, so they're going to naturally have some unlicensed vehicles. But to not do anything about this, I would challenge anybody to drive down 350 highway towards Kansas City, just past Eastwood Traffic Way, and see the chain link fences and the cars piled up down there. And that's exactly what we're going to have if we don't do something about it.
Back to Mr. Ertz.
I just wanted to clarify what qualifies when does a car become junk from a car that needs work on it?
In the existing code of ordinances, there is a definition of an inoperable, junked, derelict car, essentially something that cannot be moved with its own power. So we will make sure we look at that definition in regards to some of our surrounding cities and make sure that it's in line with the most current language to make sure we cover our bases there.
Mr. Azier.
I've heard the term dealers that have unlicensed cars on their parking lots or on their lots, and I just want to point out that businesses that are licensed dealers do have numerous numbers of dealers' license that they operate with. So if you walk in and want to drive a car, they put a dealer's license on it. So in reality, those cars are actually licensed, as opposed to someone that's just storing junk vehicles that has no immediate plan to use those, and is not selling those kind of vehicles. They have no license to operate a used car dealership. So that puts them in the category that we're actually talking about. Those are the people that we're targeting, I believe.
A lot of good discussion tonight. Staff, do you feel comfortable with the direction you've got on this? Board, Mr. Sharma?
No, Mayor and Board of Aldermen, I just thought I would make a comment tonight regarding this issue. I think as a role of governing body creating policy and legislation for the entire city, any item that comes to you needs to be debated, discussed, thoughtfully looked upon, and looked into a comprehensive policy-wise. And I think what I'm hearing tonight is a very healthy discussion. And if we are going to get a recommendation or direction from you, obviously that policy that you're going to create and ultimately approve would be thoughtful and not what I would consider a reactionary to a complaint rather than being proactive and getting towards a resolution of a problem that we all face and I hear from time to time. So I think the discussion that we had tonight is prudent, and I hope that in the future we spend more time towards any policy that comes rather than rushing into creating another ordinance or law. We thoroughly discuss it and come up with a very prudent policy for the future that is helpful to everybody. So I think the board is getting into a good habit and a good direction for any future policy. The rest of this stuff that goes on legislation is pretty mundane, routine, and a lot of those items are relied upon the professional staff to go on. But I really want board to focus on the various policy issue that we have to deal with today or in the future. So I think the course of action and the time that you're spending, rather than saying, okay, just amend that section of code and move on, and then once the complaint comes, we become a reactionary mode and try to resolve the issue. And I think from here now on, we need to make a practice to look upon. I think staff did a wonderful job in terms of providing you the existing policy, the hurdles, the issues, the research, and recommendation. And I think that would be the future course of action. And hopefully, we will provide you enough information. We'll like your feedback and give you the policy that you can live with, because ultimately, when the complaints come, you and the staff would be responsible to provide a comprehensive approach rather than one or two complaints. So I just thought it's important for me to mention it tonight.
Well said, sir. Thank you. Okay, Ms. Lynn, I think you've got your marching orders on that. Thank you very much for the presentation, and board again for your insight on that. Next, we have an item that was tabled at the last meeting. I would ask if anyone desires to take any of these tabled items off of the agenda and deal with them tonight. I remind you that it takes a 2/3 majority to actually remove it from the table and place it on the action item list. So,
Mr. Mayor, I'd like to remove that and put it on the action list.
Mr. Kramer desires that item R2397-11 be placed on the agenda for action.
A second.
Mr. Ager has a second on that. Mr. Willerth, I'm suggesting or thinking that then at this point we need to actually take a vote of the board to be certain that we have a 2/3 majority for that to come back off the table.
I was thinking that, and then I didn't know if your intent, Alderman Kramer, was just to remove it from the table to place it on a future agenda, or were you actually going to ask for that to be placed for tonight's action, sir? Then yes, this motion will require a 2/3 approval to take action tonight, Mr. Mayor.
We don't need to go any discussion before that. We just go right to the vote, the 2/3 vote then.
You can have discussion on it if you wish. That would be at the pleasure of the chair, and it's a debatable motion to remove it from the table.
It's just a motion to remove it.
The motion itself is just to remove it from the table, and that'll make it an
Let's act upon the motion to remove it off of the table item and to place it on the agenda for action tonight then. And I'll ask the clerk to perform the vote on that, please.
Alderman Kramer?
Yes.
Alderman Ager?
Yes.
Alderman White?
No.
Alderman Ertz?
No.
Alderman Hamilton?
No.
Alderman Pardue?
Yes.
Alderman Van Buskirk?
No.
Alderman Lightfoot?
Yes.
Alderman Mock?
Yes.
By my math, the motion stays tabled, or the item stays tabled. Okay, very good. Next item is adjournment. Mr. Azer's got a motion to adjourn. It is seconded by Mr. Hamilton. All in favor signify by saying aye.
Aye.
All